just point out one thing that Mr. Anderson omitted to tell you. I believe that the correct way for this body to have gone about this, had they wanted to indulge the question themselves, they could have employed the Attorney General to do something. Not take action on your own, employ the Attorney General to bring, remember he said there were two people who could bring an action for a writ of quo warranto, I think is what he said. There are two people, Mr. Felkner and the Attorney General. You could have employed the Attorney General to do it. And then Mr. Felkner could have served. All I'm asking you to do is achieve the same result as would have been achieved had you gone about it, in my estimation, the correct way. Let Mr. Felkner serve in the interim. Then there will be no harm. But if you don't let him serve, then he really has no choice. So the answer is yes, Madam Chair. There is no choice. He is compelled to do what he must.
Okay, thank you.
Mr. Anderson wanted to just address one question that was raised.
Briefly like to address a glaring misrepresentation that's been made in the support of the Bailey case, suggesting that this court has the authority to do what it did.
Sorry, would you mind going to the podium
Absolutely.
so the cameraman can hear you better?
Thank you, ladies and gentlemen. My name is Chris Anderson, no relation to my colleague. It's been suggested and commented on by members of the board that they probably don't have the authority to do what was done. And the case of Bailey v. Burns has been cited repeatedly by your counsel as justification for why this board has the authority to do what they did. In that case, the House of Representatives passed a resolution that stated, and I will be brief, quote, William H. Bailey is under a constitutional disqualification, and therefore he is not qualified to hold office as a member of this House of Representatives. Again, the House of Representatives took it upon themselves to disqualify a member who had been elected to the House of Representatives. And this case has been largely the basis that's been put forward to this board as to why it has the authority to do what it did at the last hearing. Here's the problem. Continuing to read from that case. This is the Supreme Court speaking. The House based its action upon the report of the Select Committee and was acting under the provision of Article 4, Section 6 of the Rhode Island Constitution, which reads as follows. Organization and proceedings of houses. Each house shall be the judge of the elections and qualifications of its members. The Rhode Island Constitution gives the Rhode Island House of Representatives the authority to do what it did. That written authority, that very authority that's been cited that this board has, is not there. It's not in your charter. And what the fallback position has been is to resort to the Hopkinton charter to suggest that the Hopkinton town charter somehow creates an ineligibility issue. You have an opinion letter from the solicitor for the town of Hopkinton saying, nope, not there. And further, this board cannot enforce the Hopkinton town charter. So the two bases that have been given to you by your legal counsel, I believe, are in error. One, the Rhode Island Constitution gave the House of Representatives that authority. And two, this board cannot enforce the Hopkinton town charter.
Madam Chair, I'll be real brief. First of all, as I explained to you a couple of minutes ago, the Constitution that Mr. Anderson, again, no relation, was referring to was adopted in 1843. Rhode Island's been doing this since 1687. So Rhode Island didn't need a charter to do it before.
They had a charter.
Rhode Island didn't
They
need
had
a
the King
constitution.
Charles Charter.
Okay, excuse me.
Rhode Island didn't need a constitution to do it then. They don't need a constitution to do it now. It is part of the power of a legislative body to pass on the qualifications of its members.
Okay. Well, I've heard it. I've ruled the motion out of order.
Madam
I
Chair,
am going
point of
to...
order, you cannot rule the motion out of order. It requires a 2/3 vote of the committee. Nothing Robert's rules.
Thank you. We have to vote on whether I can rule the original motion out of order. So, I take it I don't need a motion or a second. We just have to vote on whether I'm...
Well, Mr. Day made the motion that it be out of order.
Okay. Need a motion? Is there a second to Mr. Day's motion?
Second.
Mr. McQuaid?
Right, can I
Yes.
hear the motion now, please?
The motion, is Mr. Day's motion now?
Mr. Dace or Deborah Connors cannot rule the motion out of order because it requires a two-thirds vote according to Robert's rules.
But she was referring to Mr. Day's.
Is that what you wanted to hear, Deborah
No,
Connors?
No.
I'm confused because basically, my understanding is the chairman ruled the motion out.
She does not have that power under Robert's rules, which is the rules that we follow.
But as with many issues, Mrs. Carney, I disagree with you on that.
Well, I'm referencing Robert's rules of order if you'd like to read it for yourself.
Well,
Would you like me to read it for the committee?
Madam Chair,
Yes.
I thought we were going to have a civil discussion here tonight, and I find my colleague over there being a little bit less than civil
Trying to follow the rules, Bill.
to our solicitor, and I would respectfully suggest that you remind her of that.
I am trying to
trying to
conduct
follow
the
the
best
rules.
meeting as possible. If, and I'm new to this. Pitiful as it is.
Okay.
So, can I call a recess for a moment?
Would you like me to read it?
I would,
It's very short,
if it,
and it's directly to Mr. Day's motion. Again, just trying to follow the rules. If you're objecting to a consideration, if a member believes that the main motion would be detrimental to the organization to discuss, he can immediately object to its consideration. It requires a two-thirds vote in the negative, that is against consideration, to sustain the objection and not consider the main motion. In taking the vote, the president asks, shall the motion be considered?
and with all due respect, the chair made a ruling. You don't agree with this ruling. You need to make a motion to challenge the ruling of the chair. And if you challenge the ruling of the chair, that's a majority vote.
That's great, except her ruling is against Robert's rules,
No,
and
her
we're
ruling is
following
not
Robert's
against-
rules.
With all due respect, it's not. I would appreciate it if you would read the motion to, the section on the motion to rescind. I also would appreciate it if you would read this committee's rules of conduct. I understand that you were not a member of the committee at the time, but there were considerable complaints made by certain members that things were being put on agendas.
Right, and in response to that, I did read the rules quite thoroughly after the last meeting, and it did say, in the absence of any other rules, Robert's rules would apply, and that's all I'm trying to follow. If we're gonna choose not to follow Robert's rules, then let me know now, so I know what process we're working
With
on.
all,
I am
with
not
all due
trying to be
respect, Mrs. Carney,
argumentative.
you're following neither Robert's rules nor the rules of conduct of this
I'm-
committee, nor,
I'm reading Robert's rules.
with all due
It's right
respect, I
here.
direct you to the section on the motion to rescind.
Well, then, with all due respect, I disagree.
I need a
I'll give you the page
recommendation,
reference if you'd like.
Mr. Anderson,
I'm
as
sorry,
to-
I'm checking it.
I make a
There's
motion
been
to
a
recess
challenge.
so that you can get the legal recommendation.
Can I recess in the middle of the
Can you do that?
That's a good idea.
Needs a second. Hate to be a stickler, but it needs a second and it needs a vote.
May I have
That's
a
if
I'll
we're
second
following
it.
Robert's rules.
I'll second it.
And can we have a motion to recess, please?
I make a motion.
vote.
I make a motion.
We get a vote. Motion to recess, please. You ready to do this? Opposed? Devin, Richard, and abstaining?
No, I voted yes.
Voted to recess, I'm sorry, I didn't see your hand up, George. Okay, 5-minute recess, please. Okay, let's go back and look at the minutes to clarify a few things. I'd like Donna to start with reading back the minutes to clarify. I heard Bill Day's motion, and I'm sorry for the confusion, but Bill Day, I'm going to start from something that he said. He didn't really make a motion, he was supporting something. So if we can have the minutes, please.
The confusion lies in the fact that Bill Day stated 4 of the members of this committee voted to appoint Mr. Anderson. He doesn't always understand legal things, but he does understand this, and Mr. Anderson's promised to expedite the issue. If the school committee allows Mr. Felkner to return, we will take this issue out of court. He moves to support the solicitor and asks the chair to rule the motion out of order. There was no second, there was no motion made. Holly Eaves then ruled the motion out of order, have it placed on the next agenda, which would give the committee time to study this and have legal counsel's advice to review. So Bill Day did not make a motion, there was not a second. The motion